What is bankruptcy? Bankruptcy is a legal process that provides relief for individuals or businesses overwhelmed by debt. It's a federal court procedure designed to help people eliminate or repay their debts under the protection of the bankruptcy court. The primary goals of bankruptcy are to give debtors a fresh financial start while ensuring creditors receive fair treatment according to established priorities. Bankruptcy is governed by federal law, specifically the U.S. Bankruptcy Code, though state laws can affect property exemptions and other aspects of the process. There are 6 types of bankruptcy under the United States Bankruptcy Code, each designed to address different financial situations. Let's first explore the 3 most common types of bankruptcy. Chapter 7 is known as liquidation bankruptcy. In this process, a trustee sells the debtor's non-exempt assets and distributes the proceeds to creditors. It's typically used by individuals with limited income. Chapter 13 is a reorganization bankruptcy for individuals with regular income. It allows debtors to keep their property while repaying all or a portion of their debts through a court-approved repayment plan lasting 3 to 5 years. Chapter 11 is primarily used by businesses. It allows companies to continue operations while restructuring their debt obligations. This complex process can take years and involves negotiating with creditors while developing a reorganization plan. There are also 3 less common types of bankruptcy that serve specific needs. Chapter 9 applies to municipalities like cities, counties, and school districts, allowing them to reorganize debts while continuing to provide essential services. Chapter 12 provides specialized debt relief for family farmers and fishermen, allowing them to keep their operations while repaying creditors over time. Chapter 15 addresses international bankruptcy cases, coordinating proceedings when assets or creditors are in multiple countries. Each bankruptcy type has specific eligibility requirements that determine who can file. These requirements are based on factors such as income levels, debt amounts, the type of entity filing, and whether you filed for bankruptcy in the past. Chapter 13 bankruptcy creates a structured repayment plan over 3 to 5 years, allowing you to keep your assets while paying back a portion of your debts. The Chapter 13 process follows several key steps, from initial filing through plan completion and debt discharge. Step 1 involves filing your bankruptcy petition. Before filing, you must complete a credit counseling course from an approved agency within 180 days of your filing date. You'll submit various required forms documenting your income, expenses, assets, and debts, along with the filing fee. Your repayment plan will span 3 to 5 years, depending on your income. If your income is below your state's median, your plan typically lasts 3 years. If it's above, you'll need a 5-year plan. Your plan must pay all priority debts in full, such as recent taxes and child support, and unsecured creditors must receive at least as much as they would in a Chapter 7 bankruptcy. You must begin making payments to your bankruptcy trustee within 30 days of filing your case, even if your plan hasn't been approved yet. These initial payments go to the trustee, who holds them until your plan is confirmed. The trustee then distributes these funds to your creditors according to the priorities in your plan. Your Chapter 13 plan must follow specific payment priorities. First, administrative fees, including trustee and attorney fees, must be paid. Next, ongoing secured debt payments, like your mortgage or car loan. Then, priority debts such as recent taxes and child support. Finally, your unsecured creditors receive pro rata payments from any remaining funds. Your plan must be confirmed by the bankruptcy court. For confirmation, your plan must be feasible, meaning you can actually make the proposed payments. It must be proposed in good faith and comply with the bankruptcy code. It must meet the best interest of creditors test, meaning creditors receive at least as much as in Chapter 7. And secured creditors must either accept your proposed treatment or you must pay them the full value of their collateral. To complete your Chapter 13 plan, you must make all required payments over the 3 to 5 year period. You must also complete a financial management course from an approved provider. Certify that you're current on any domestic support obligations and file the appropriate certifications with the court. After successfully completing all requirements, the court will grant a discharge of your remaining eligible debts. To summarize the Chapter 13 process, you'll create a 3 to 5 year repayment plan based on your income and debt levels. You must begin payments within 30 days of filing, even before your plan is approved. Your trustee will distribute these payments according to legal priorities. You must complete 2 educational courses during the process. After successfully completing all plan payments, remaining eligible debts are discharged. Property exemptions in bankruptcy allow you to protect certain assets from being sold to pay your creditors. There are 2 exemption systems, federal and state. Many states require you to use their own exemption system rather than the federal options. Common exemptions include your homestead or equity in your primary residence, vehicle equity up to certain values, and retirement accounts such as 401k plans and IRAs. You can also typically protect household items like furniture and clothing, as well as tools and equipment needed for your work. In Chapter 7 bankruptcy, non-exempt property may be sold by the trustee to pay your creditors. In contrast, Chapter 13 allows you to keep all your property, but you must pay creditors at least the value of your non-exempt assets through your repayment plan. Exemption amounts vary significantly from state to state. For example, California offers a homestead exemption up to $600,000. Florida has an unlimited homestead exemption, while Alabama offers only $16,450 in homestead protection. It's crucial to check your state's specific exemption amounts before filing for bankruptcy. Not all debts can be eliminated through bankruptcy. Let's examine the types of debts that cannot be discharged through bankruptcy. In contrast, many common debts can typically be discharged through bankruptcy. Student loans are particularly difficult to discharge and require a separate legal process. Secured debts like mortgages and car loans follow special rules in bankruptcy. When facing financial difficulties, several alternatives to bankruptcy should be considered first. Debt management plans work with credit counseling agencies to create payment plans with reduced interest rates. Debt settlement involves negotiating with creditors to accept less than the full amount owed. Debt consolidation combines multiple debts into a single loan with better terms. Other options include selling non-essential assets to pay down debt, modifying loan terms for homeowners, and exploring hardship programs offered by many creditors. When considering these alternatives, several factors should be evaluated. While these alternatives may help many people, bankruptcy may still be necessary in certain situations. Bankruptcy should generally be considered as a last resort when debts are insurmountable, collection actions are imminent, and other options won't provide adequate relief.